Are excessive jury awards an economic millstone or essentially a myth? Legal fees, how much is too much and how should that be decided? The administration of justice. When one branch of government sets the rules for another, how easy should it be? Both sides of a very controversial proposal. Next on Arkansas Week.
Local broadcast of Arkansas Week is made possible in part by the award-winning Arkansas Democrat-Gazette, Arkansas's largest major newspaper, bringing you local, national, and international news since 1819. By the Arkansas Times, keeping you informed by covering people, events, and politics in Arkansas. By FM 89, KUAR in Little Rock, with in-depth news reporting, analysis, and discussion each weekday.
Hello again, everyone. Thanks for joining us and welcome to a special edition of Arkansas Week. We're focusing on Issue 1 to be decided by voters on Election Day, provided the votes are counted. Yes, Issue 1, an amendment proposed by the state legislature, is under legal challenge. The Supreme Court is deciding whether the measure is properly drafted or whether it's too sweeping, whether it tries to do too many things at one time. Certainly, it would do a lot, affect certain legal fees, cap certain damages in lawsuits, and allow legislators to write the rules for the courts or have a freer hand anyway to do so. We have both sides represented tonight. Representatives for Issue 1. Jody Ann Tritt is Executive Vice President of the Arkansas Hospital Association. Carl Vogelpohl, Campaign Manager for Arkansans for Jobs and Justice. On the opposing side, representatives against Issue 1, retired Justice Annabelle Tuck, who is chair of Defending Your Day in Court, and Jesse Gibson is president of the Arkansas Trial Lawyers Association. If you haven't been watching television, we're going to do you a favor. Maybe. We have commercials that have been running for and against Issue 1, and we're going to go ahead and take a quick look at those because they really have been inundating the Arkansas media markets, plural. Let's take a look at the for commercial.
Arkansas, the natural state, the land we love, and the place we call home. Protecting our home means voting yes on Issue 1, because yes means recruiting good doctors, growing Arkansas businesses, and strengthening families. It means lawsuit reform that protects Arkansans from abusive lawsuits and greedy trial lawyers. Vote yes for jobs, yes for quality health care, yes for families, yes for Arkansas. Vote yes on Issue 1.
And at the same time, or subsequent to that, we thought we'd give you a refresher course in the positions against, at least as presented by the antis.
An Arkansas life, a beautiful thing, but Issue 1 would put mandatory limits on the value of life in court cases when negligent behavior results in injury or even death. Arkansas citizen juries should decide court cases, not government mandates. Corporate lobbyists are trying to rewrite our state constitution to protect special interests from being held accountable by a citizen jury. How much is one life worth? Our child?
And back we are. Since we closed with the against commercial, why don't we try to do it this way? And the goal here is some balance and at the same time hit all the issues. But let's start with what's often called tort reform, and that's a cap on certain damages. So Jody and Fred, why don't we start with you?
Sure. The easiest way for me to present why the Arkansas Hospital Association is a part of this group that is actually for tort reform is we have a really blank spot on the map of the United States when it comes to capping non-economic damages for healthcare providers. So we want the very best healthcare providers to come into Arkansas and to stay here when they get here. One of the most difficult things to do is to recruit new physicians in between, right when they graduate and into their residency programs. We know that where a physician practices or attempts to do his or her residency is most likely where he or she will choose to practice in the long term and in the long run. So with physicians graduating all across the country and with the social media age and everything else, it's a recruiting tool to make sure that you can say, hey, if something happens, you've got some protections. You have some certainty and some consistency in what might happen to you if you're sued. All the states that touch Arkansas, that is the case. Arkansas, that is not the case. So we want to be able to have in our arsenal the ability to recruit and retain great doctors.
All right, Mr. President.
Well, I think that the issue of tort reform, it's again a solution in search of a problem. In Arkansas, we are a very conservative state. Our juries are very conservative. Only 9% of all court cases are tort cases. By contrast, 60% are breach of contract cases. And it might surprise some people to know that the median jury award in Arkansas is $3,757. Now, I know we all at this table would like to attract good paying jobs to our state, but the question is how to do that. I know when SJR 8, which became issue 1, was going through the Senate, the question was posed on the floor. Is there a company that has not located to Arkansas because of our tort climate, or is there a company that's left because of our tort climate? And the silence was deafening. In fact, in Arkansas right now, our job market's pretty good. Record low unemployment. Even the president of Arkansans for Jobs and Justice was quoted in a Talk Business article, an Arkansas Business article, saying that every Arkansan who wants a job can now get a job. And that our biggest problem right now is job training. That was Randy Zook, who is the chairman and CEO of the Arkansas State Chamber of Commerce, and I agree with him. So let's do the hard things. Let's do job training. Let's do education. We shouldn't do this on the backs of the most vulnerable people in our society. Children, the disabled, people injured through no fault of their own. I think that the caps form of this would also place an immoral cap on the value of a human life. Again, children, disabled, and the elderly. Something that I don't think is proper, something I don't think is fair. And then again, the rulemaking. Shifting that power of rulemaking from the court, which is an open system with debate on both sides, openness, comment, and shifting that to the legislature creates a Pandora's box, as we know every time we pick up the newspaper, about what could happen if those people are in charge of writing our rules.
Let me stick with tort for just a second if I can. Carl Vogelpohl, what the runaway jury in terms of tort? Myth?
So what I can tell you is,
overstated.
Well, I think what I can tell you is that when you look at the states that surround Arkansas, and you look at what job creators tell us and economic developers tell us, and consider what factors companies, large and small, consider when they decide where to locate jobs and where to grow jobs, that having common sense tort reform is a key component of that. And the governor of Texas, the lieutenant governor of Arkansas, said that tort reform is part of the formula of economic development and job creation. It's not just workforce development, which is important. It's not just tax reform that's important. It's not just regulatory reform. It's tort reform. And frankly, of that formula, tort reform is the only thing that's on the ballot in November. And that's why the Chamber of Commerce is part of this, of the committee. That's why job creators, large and small, have joined together. Farmers and doctors and truckers have joined together to try to pass common sense tort reform in Arkansas.
Yeah, but you can your side point to some what you would consider obviously excessive jury awards?
I think what we can point to is that every day in Arkansas, a woman wakes up and realizes that she's going to have to drive by her local hospital to find a doctor who will deliver her baby. Every day in Arkansas, there is an Arkansan who is in a contingency fee contract that will take more than a third of their settlement, large or small, and that's an important competitive disadvantage for Arkansas.
But can you cite any that stand out? Excessive judgments on tort.
Yeah, I think you can.
Damages.
I think you can look through and you can talk about, and I think it's important on punitive damages that punitive damages for intentional misconduct are not capped. So even under this law, if there is a jury verdict and the judge and the jury determine that there is intentional misconduct, there are no caps on intentional misconduct in this law.
All right, Justice Tuck.
Yes, obviously, I have been in the judiciary for many years, both as a trial judge and as an appellate judge. And I can tell you, based upon the statistics at the Administrative Office of the Courts, we do not have runaway juries. We have juries that are actually very fiscally conservative. And as mentioned earlier, most of the cases are not tort cases. They're contract cases or they're family law cases. That's what Arkansas has. And just because you have other states that have tort reform, I know of no statistics from Arkansas that show that companies are not coming here because of no tort reform, or because they're concerned about juries. In fact, Arkansas, according to the U.S. Chamber of Commerce survey, has a better rating for business in our courts than Texas, which has had tort reform since 2003.
Ms. Tritt, I'll come back around to you.
Sure.
What, your response? The runaway jury argument?
I will re-emphasize that the thing that makes us most vulnerable when we're trying to recruit folks is that one of the things that is used is whether you have tort reform in your state or not. So what it does in the medical field and the healthcare field for hospitals in particular is that we don't even get to talk to those physicians who are graduating in other places because they look at the map, they see that we don't have it. So if there are runaway juries for whatever verdict, we want to, as Carl said, make sure that that very patient is who we're protecting. We want to make sure that that very patient recovers at least 2/3 of whatever happens in that particular incident, where we hope that nothing would have happened in the first place. So can I point to a specific case to where I feel like it's a runaway jury? I've never even sat on the bench of a jury. I know a lot of things come into play in those trials. So to say, do I feel like there's been a runaway jury in a particular case, I can't speak to that. I have no personal knowledge of how that would work. I do know that having an environment where we can promote, recruit, and keep the best and brightest healthcare workers values all of our lives greater. And having common sense tort reform is better for Arkansas than having nothing, which is what we have now.
Well, the argument, though, about capping the value of a human life, regardless of the circumstances of any mismal or nonfeasance or malpractice, is the term that
sure
obviously applies to the hospital industry.
Sure. So I have a hard time with that argument because the economic damages that folks get, so that's your lost wages, lost property, your medical bills that you receive, those are valued by a court. Lost wages definitely is placing a value on what you could be one way or another. Initiative 1 doesn't change that particular piece of it. What it modifies is pain and suffering and those things. And the thing that is important to remember is that juries all across Arkansas look at facts and value things differently. So even if you had 2 cases in our state that have almost the exact same facts, you don't have any certainty in the medical field. You don't have any certainty for businesses that those cases would be decided in a similar way for folks to say, okay, I feel comfortable investing in, or I feel comfortable moving in, or I feel comfortable practicing in a state where if I'm in Logan County, which is where I'm proudly from, a jury might decide things one way, or in Mississippi County, a jury might decide things another. And I think the business and the medical community both deserve some certainty in what those pain and suffering verdicts might look like. And then again, I'll say, the attorneys for sure need to make sure that when those things happen, when those never events occur, that at least 2/3 goes to the actual victim, the patient, the person who's been harmed.
All right, Jesse.
Well, to counter that argument, what about children? What about the disabled? What about the stay-at-home moms? Their lives are priceless. Under issue 1, they would not be treated the same as someone who might be an executive or who might be a wealthy CEO. That discrepancy is what really the issue of the life being priceless is all about. The simple fact is under Arkansas law, unless you have a earning history, which a child doesn't have, a disabled person doesn't have, economic damages are not available to you. And I don't ordinarily get to meet nice people in a setting like this. When I meet new people, it's usually on the worst day of their lives. when someone has been raped or abused in a nursing home, or when a child has been left in a van, unfortunately, and has died. I've seen some horrible, horrible things. And in both those situations I just mentioned, they don't have earning capacity. They don't have the ability to earn, and so their lives are just deemed less valuable under Issue 1. And I think that belief and that fact is what unites both people on traditionally the left and the right. Issue 1 is one of those things that's united groups as disparate in political leanings as AFL-CIO, labor unions, and the Arkansas Family Council. Groups like the Sierra Club, and also Conduit for Action. Groups like the Arkansas Trial Lawyers Association, the Arkansas Bar Association, and Rose Mims of Arkansas Right to Life. Politically speaking, when you can stake out groups on the left and the right, you've got a winning combination there in the middle. I think those groups are illustrative of why Issue 1 is bad policy. A bill that can unite those groups is a bad piece of legislation, a bad amendment. The caps are something that I believe is just an immoral thing to do based on someone's earning capacity. We always talk about it, and one of the things in the medical community they always talk about is lowered malpractice premiums. I think is what we're talking about attracting doctors. I'm old enough to remember the Civil Justice Reform Act of 2003. And in that emergency clause, it stated that the purpose behind that act, which was the first attempt at tort reform in 2003, in the emergency clause, it said that the purpose is to reduce malpractice premiums. Okay? In the 8 or 9 years that was in effect, even in the first year, the amount of claims did go down. But in 8 or 9 years, the Arkansas Insurance Department tracked malpractice carriers coming in, leaving, and rates. It might surprise you to know there was no change in 8 or 9 years. And in fact, in Arkansas, right now, we are the 10th lowest medical malpractice premium state in the country. Texas, that we've heard about as a comparison, 23rd from the bottom. We have lower malpractice premiums in Texas. What will happen in Arkansas if Issue 1 passes is what happened in Texas. And I urge everyone to look at the Texas AARP report called Intolerable Care, which says that since tort reform was instituted in Texas, their nursing care is the worst in the nation. The worst.
Let me shift to Mr. Vogel to get the last word on this particular part of Issue 1. Carl, why doesn't the medical community, medical community is a principal, the clinical community, a principal driver of Issue 1, I think you'd agree. Why not just be more careful?
I think there's a combination of factors. I think, first off, it's not just the medical community. It's job creators, large and small, who are part of this coalition. It's not just doctors.
It's broader than the clinical community.
It's definitely broader than the clinical people. Yeah. And I think it's important to remember that bad actors will still be punished under Issue 1. We all want high quality of medical care, but I contend that the ability of a trial lawyer to bring a lawsuit that they can get more than half of that suit as a settlement as part of their contingency fees doesn't drive high quality medical care. What does help us have high quality medical care is the ability to attract doctors. It's the ability to attract medical professionals. It's the ability to bring in jobs to help, Arkansans in communities large and small. And that's what this coalition is about those factors that are the impacts of tort reform and putting Arkansas on a level playing field when we work to grow jobs and to attract doctors.
Got a lot to cover, so let me move on very quickly if I can, and that's the question of contingency fees, which Issue 1 would address as well. Your Honor?
Well, contingency, as you know, the issue of contingency fees is really an agreement between the client and the lawyer. So this is about freedom of contract. And so this would be a provision in the Arkansas Constitution restricting freedom of contract. I know of no other provision that restricts between a private business, this is not a government issue, between private individuals and lawyers, their ability to negotiate a contract. Now, I would defer to Jesse Gibson on the costs for lawyers to bring these types of cases. They have to pay for expert witnesses, they have to pay for depositions. It's very expensive. In case your audience doesn't know, a contingency fee contract means if I lose your case as a lawyer, I get nothing. I get 0. If I win your case, we have negotiated whether if the case settles a certain percentage, if the case goes to trial a certain percentage because there's more work involved. As a person who has been chair of the Arkansas Access to Justice Commission in the past, my concern is this: contingency fee contracts are the poor person's way to get into the courthouse, and this will close the courthouse doors.
Carl Vogelpohl, is it not in fact just a sideways attempt to hold down tort litigation?
So I think that
by capping contingencies at a third.
I think, to be clear, the Arkansas Constitution does limit what some businesses can charge in certain situations. For example, we limit what interest rates can be in loans, right? We don't let payday lenders or predatory lending fees happen in Arkansas, and that's in the Constitution. Contingency fees are an important access to justice vehicle. It's absolutely important that we have contingency fee contracts, but to Jesse's point earlier, he does see people sometimes when they are in one of the most traumatic times of their lives. And just like the Arkansas Constitution limits the ability of a gas station to gouge during a crisis, Issue 1 would limit the ability of these contingency fees to take more than a third of a victim's settlement in a case. And it's not something new for Arkansas. There are contingency fee caps around the country. Contingency fee caps in Florida get down to 10% on some medical malpractice cases. So I think it provides, with Issue 1, it provides a fair access to justice pathway, but it also protects victims and allows them to keep more of their settlement.
Shouldn't that, though, should that be between counselor or between an attorney and client?
Maybe it should, but I think Carl makes a really great point.
Private transaction, as Justice Tuck.
Sure. Well, I think Carl makes a really great point, and that is when you are in that situation and you're terrified and you're not probably a great negotiator of contracts or many other things, especially in that state of mind when something horrible has happened to you or someone you love. Likely the power of contract negotiation shifts to the attorney who does these things routinely on an everyday basis. We would hope that a never event that happens to a family wouldn't make someone an expert at contracting with an attorney.
Okay, now on to a third aspect of Issue 1, and that is it would, if approved, it would grant the legislature, the General Assembly, a far easier path, smoother path to regulating the court system. Mr. Gibson, Mr. President, we'll start with you. Abhorrent to the judiciary.
This should frighten the viewers. The potential for abuse here is obvious. Let me talk to you a little bit about why that is.
With all respect, pretty quickly.
Sure.
I want to give the other side.
Sure. What we have is lawyers and the judiciary have a toolbox and a mechanism to say no to power, to say no to insurance companies, to special interests, to wrongdoers. It's called the courthouse. The issue that's different from the legislature to the judiciary is the legislature does not have the ability oftentimes to say no to special interests. I've seen it personally, and I'm empathetic to those legislators. Special interests, lobbyists, wield great power in our legislature. And that's the big difference. And that's why I think this should scare the people of Arkansas, is that the legislature sometimes cannot say no to those special interests. And I'm empathetic. But the courts, they are constructed so that lobbyists don't have influence, that people cannot go to the judge and tell them how they want to rule, or go to the jurors and tell them how they want to rule. I think what you'll see is a real problem brewing about what kind of justice you can afford. Not blind lady justice who treats the prince and the pauper the same. You'll have a difference of opinion about what justice means based on how many lobbyists you can get. That's troubling. And I think from a 30,000-foot view, there's a real struggle for the soul of what the judiciary means. Is it a co-equal branch of government that puts checks and balances on the legislature? Or, as I think some in the legislature might want to do, for it to be a policy arm for them to further their policy agenda?
Carl Vogelpohl, a serious argument on separation of powers or no?
So I think checks and balances are extraordinarily important in our system. It's important at the federal level. And at the federal level, the Supreme Court proposes rules that the Congress can either accept, modify, or reject. So what we're proposing in Arkansas isn't that unique compared to our federal system or other states around us. But I think it also goes back to, I'd point out that in Arkansas, lawyers and lobbyists are the single most, they give the most to the political class, they give the most donations. The Arkansas Trial Lawyers Association is a powerful lobby. I think that issue 1 provides a shared check and balance between the judicial branch and the legislative branch. And let's be candid and honest about this shared responsibility. We have a Supreme Court that almost 100% of the justices were just brought up on ethics charges by an independent commission. We have judges in Arkansas, and to talk about the courthouse and the closed system in the courthouse, we have judges in Arkansas that have done horrible things to victims as part of this judicial system. So I think it's important that we allow the policy branch of our government, the legislative branch, to pass rules that affect the entire state that are policy rules, while still allowing the Supreme Court to conduct their business the way they do under the judicial branch.
Justice Tuck, seconds remaining, and I'll grant them to you.
And I will tell you, as a former member of the court, we have a process or the court does have a committee process that's open, and proposed rules are published for comment. I want to comment specifically on this issue of the 6 of the Supreme Court justices having disciplinary charges. That is the point. There is a way, there is a commission that will make judges accountable. That is not true with the legislature other than the criminal law. This is not a criminal charge. It's an ethical charge. And what I'm sharing with you is there is accountability, whether it's at the ballot box or through the Judicial Discipline Commission. I'm not going to say how that's going to come out because it is merely a claim at this point. But my concern is the way legislation is made, it wants to give a benefit to some constituent. That's okay for substantive law. But my question is, when you're starting to make the rules of practice and procedure, which is what evidence can come in, who can testify, what kind of experts can come in, whether you can have a class action or not, that needs to be even-handed and neutral. And that's why my committee, the D-Day committee, is so involved in talking about that issue that is not being addressed in advertising.
To the 4 of you, I thank you for giving us what I hope was an even-handed and neutral discussion of one.
Thank you.
And it's time, as we're out of time, but we've got just enough time to remind you that the Earth will move on its axis. The axis will shift anyway. 1 week from tonight, when Arkansas Week, after several years, moves from 7:30 to 6:30. And we'll see you then next week.
Local broadcast of Arkansas Week is made possible in part by the award-winning Arkansas Democrat-Gazette, Arkansas's largest major newspaper, bringing you local, national, and international news since 1819. By the Arkansas Times, keeping you informed by covering people, events, and politics in Arkansas. By FM 89, KUAR in Little Rock, with in-depth news reporting, analysis, and discussion each weekday.